Hello, I'm Justin Schuhmacher with Indiana Estate and Elder Law. Oftentimes in our practice, we get the question, is it too late for Medicaid? Or when is the best time to plan for Medicaid? Well, in reality, the best time to plan for Medicaid is always 5 years ago. Many of you may be aware of Medicaid's 5-year look-back window. And the way that rule works is if I've applied for Medicaid benefits to help pay for my long-term care, I have to disclose whether or not I have transferred assets out of my name in the form of a gift in the 5 years prior to the date I'm applying for this benefit. So certainly, if I'm incredibly proactive and I've got a very good and robust estate plan put together when I've been contemplating these things, and I've done this well in advance of any potential time that I might need to utilize these benefits, if I've got the plan put together and more than 5 years have passed from the time I've finalized this plan and now I need benefits, I'm probably in a pretty good position. The issue we oftentimes run into is that people often have misconceptions about the Medicaid rules. Imagine that. Certainly it's a very nebulous and complicated set of rules that we have the great joy of helping clients navigate through. That's why they get a hold of us, because certainly to try to handle this on your own without any experience can be incredibly overwhelming. There's so much misinformation out there, and there's so many things that really lead people astray or discourage them from even asking the questions, because sometimes, again, people think it's probably too late. I didn't set this up more than 5 years ago. I really don't have any options. My only choice is to now spend myself down to nothing. And that's simply not true. Again, if I go back to the question, is it too late for Medicaid? The answer is probably no. I like to say there's always a solution. Some solutions are a little prettier and a little more favorable than others, but there's always a plan that can be utilized. Like I said, the best case scenario would be really being proactive and trying to plan ahead, and hopefully in the event we ever need to utilize these benefits, I've got a comprehensive plan that's been put together more than 5 years in advance of when I'm seeking these benefits. However, let's say I haven't. Let's say I've always talked about getting some kind of planning put together, or maybe it was mom or dad had always talked about putting some kind of a plan together, but they just didn't get around to it, and now we are in what our office likes to refer to as crisis mode. And we refer to that in a situation where we've done no prior planning, and now we're really seeking some benefits, and it's the 11th hour, hair's on fire, everybody's stressed out because they don't know what to do, they don't know what their options are, they don't know where to turn next. And unfortunately, so many people do get discouraged because they think, oh shoot, I've heard about this Medicaid 5-year look-back rule, we didn't put a plan together more than 5 years ago, we're in a bad spot, we have nowhere else to go. And again, that's where it's really important to seek out a professional that does this day in and day out, that is familiar with the rules, and that understands that there's still a solution. Not to get too deep into the weeds, but long story short is, even if I've done no prior planning, and I'm in the 11th hour, I need benefits right away, or I need some kind of very significant care right away, and I've not been all that proactive, if I contact a trusted professional, someone, an elder law attorney who does this stuff on a regular, recurring basis, there's still a very good chance that probably close to half of your entire asset structure in the value can still be protected. Is it the perfect scenario if my goal is protection of assets and still utilizing Medicaid to pay for long-term care benefits? No, it's probably not the best scenario, but it's still a scenario that can work. It's still a solution that can be available for you. And the long and the short of it is, I probably, in a perfect world, I've set up a trust to protect assets well in advance, and hopefully maybe I never need it, but in the event that I do, it's there, my assets are protected. However, in this scenario, kind of when we are in that crisis mode, again, it's not too late. I can still establish a trust. I can still transfer assets to that trust in order to get my countable asset level down below the threshold that Medicaid requires, because again, it is a financial means-based benefit program. So I again can get my countable asset structure down below the threshold, move those excess assets to my trust, but then all I do is disclose to Medicaid, guess what? I transferred things away out of my name into this trust. And yes, it's been within the 5-year period of the time I'm seeking benefits. What's going to happen in that circumstance is we compute all the numbers. Again, it's a numbers game, and we're going to crunch these numbers, and we're going to estimate what our client's Medicaid penalty is. The word penalty scares people. Oftentimes we hear penalty, we think it's a bad thing, and it's not ideal, but at the same time, sometimes it's the best case scenario we have at our disposal. So when we crunch all these numbers, we get this Medicaid penalty. What that's going to do is measure the duration of time in months that we will not qualify for Medicaid because we transferred the assets out of our name. Now, the good news is it's not a dollar for dollar ratio. It's based on several factors, which we probably don't have enough hours in the day to go through for this video segment, but it's based on several factors, and it calculates an estimated penalty once we punch those numbers and crunch those numbers, etc. Once we get our Medicaid penalty estimation, again, measured in months, what that's going to tell us is for each of the months of penalty, we take the assets out of that trust, pay it back to me, the benefit applicant. I then pay for my share of the long-term care services. And I do that every single month from the trust back to me to pay my services or for my services until that penalty period expires. And again, more often than not, what we're going to find when we do that, we're still able to save and salvage and protect probably very close, maybe in many cases a little more than half of the applicant's total assets. Again, this is in a situation where I've done no pre-planning. I can't utilize spousal rules to help transfer things between spouses and not have that count against me, and I still can protect a good portion of my assets. Now, on the other hand, again, if we ask that same question, is it too late for Medicaid, and I am a married person, and my spouse is sitting over here, and my spouse is healthy, vibrant, doesn't need any kind of services, I probably can protect 100% of my assets, even if I've done no prior proactive planning. So again, in a married couple situation, it is absolutely not too late to do Medicaid planning. Even in that 11th hour, we can likely protect at or very near all of the assets that the household has together. In that circumstance, the applicant is allowed to transfer assets to one human being on the face of the planet without it causing a Medicaid penalty. That one human being is my spouse. So I'm able to actually transfer assets to my spouse, get that out of my name, reduce my asset level to beneath the threshold that Medicaid allows, and now I'm going to be financially qualified to seek that benefit and qualify for that benefit in order to pay a big brunt of my long-term care expenses. Now, there's a couple exceptions to both of these scenarios. We have to take special consideration for IRAs, because if I have an IRA, we also have to account for tax withholding if it's in the best interest at that time to liquidate all or a portion of that IRA to make the planning work in that crisis mode. So we have to take those things into consideration to weigh the analysis to see if it's worthwhile. We have the spouse that's healthy has some parameters they've got to work within, but certainly the best case scenario is, I can always tell people, even though there are caps for what the healthier spouse is allowed to have, it's not the end of the world. We use a couple different tools at our disposal to actually help the healthy spouse essentially keep all the assets. So long-winded reply, but it's a question we get so often. Is it too late? The answer is almost always no. The only time it is too late is in the event that I have not picked up the phone, I've not contacted someone that knows what they're doing to help me in this regard, and I've literally spent myself down to zero. Those are the times when I have great regret, when I have to talk to the family and say, boy, I wish you'd have talked to us 2 years ago. Or boy, I wish you'd have known and reached out and got some advice on this, several months back or 3 years ago or whatever it was, because you had some solutions that could have worked for you. Medicaid is pretty tricky. It's pretty complicated. It's something that if you're not doing it every day, you run the risk of taking a hard turn the wrong direction, or there's so much misinformation out there that it's easy to get discouraged, be filled with stress and anxiety, worried that you don't have any options, and most of the time those are things you don't need to worry about. Again, that's why you have us at your disposal, so that we can hold your hand through this, we can guide you through this, we can explore all the options that are available. Again, there's always a solution. Some are maybe just a little bit more favorable than others. If you want to know more about this, if you have a specific concern for your own situation, please do not hesitate. Reach out, get a hold of us for a consultation. We're more than happy to do the very best we can to figure out what options, what planning is going to work the best for your very specific situation. Again, Justin Schuhmacher with Indiana State and Elder Law. Thank you.